Hi, everyone. This is Marissa Machado, COO for the Texas Association for Home Care and Hospice. I'd like to welcome you to Improper Home Health and Hospice Marketing Practices. Are your marketing practices legal? We are so excited again to have the partnership with Lyles Parker Attorneys and Counselors at Law, and very grateful for their continued support of TAC and of the industry. Our speakers today are Michael Cook has more than 38 years experience representing health clients of all kinds in regulatory, reimbursement, fraud and abuse, compliance, business strategic planning, and public policy matters with a strong emphasis on post-acute providers. At the beginning of his career, Michael was also an attorney with the Office of General Counsel at the United States Department of Health and Human Services, where he represented the federal regulators of the Medicare and Medicaid programs on matters of the highest legal and political sensitivity. He recently received the honor of fellow from the American Health Lawyers Association. In addition to his healthcare practice, Michael serves as a strategic healthcare advisor to a startup company that has developed a healthcare-related product to protect seniors from fractured hips. He was appointed by Governor McAuliffe to serve on the board of the Department of Medical Assistance Services that advises Virginia's Medicaid program, has served as a healthcare advisor to a number of candidates for state and national office, and recently received the Albert Nelson Lifetime Achievement Award from Marquise Who's Who. He frequently lectures on topics of interest to healthcare providers, and earlier this year presented on the topics of internal investigations for healthcare companies at the 2019 American Health Lawyers Association Conference on Medicare and Medicaid Payment Issues, and moderated a panel of state Medicaid directors on the changing face of their Medicaid programs in post-acute care for the AHLA Long-Term Care and the Law Conference. Also, we have Heidi Kocher. Heidi is a partner with the law firm from Lyles Parker. She has over 20 years experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert of all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a chief compliance officer, chief privacy officer, and implementing various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurance up through the ALJ level. She received her JD from Georgetown University Law Center. She's licensed in Texas and Maryland and is admitted to the U.S. Court of Federal Claims. She is also certified in healthcare compliance. Great speakers, and I'm so excited for this webinar. Welcome, everybody. If you're interested in the CEs for the program, I believe those are included. Those are an additional fee. So any members online, there is an additional fee to purchase the CEs for that. Otherwise, your program webinar is free if you're just listening today. So enjoy the conference, enjoy the webinar, and hope to hear and see y'all at some time. We do have some exciting events coming up, including our annual meeting. And so be looking for our emails for that. We have committee board meetings, and then the conference beginning on August 28th. So have a great and wonderful day. Take it away, Michael and Heidi. Thank you so much.
Thank you very much, Marissa. Good afternoon. As Marissa has told you, my name is Michael Cook, and Heidi and I will be discussing the topic of whether your marketing practices are legal, principally with the laws that address fraud and abuse. We'll be covering the various federal healthcare laws and guidance from the Office of Inspector General, relevant Texas laws and guidance, a discussion of problematic marketing practices, including some real-life cases, And then perhaps most importantly, at the conclusion, we will be discussing some compliance tips. In doing this, we will also be touching on a variety of practices that the federal and state governments consider to be problematic in the industry that may not at first glance appear to be related to marketing practices. However, we'll be tying those back to the marketing issue, especially as we discuss compliance tips. As one last comment before we get into the substance, marketing is a critical function of any organization. However, as a friend of mine in another law firm once said in one of her lectures, the marketers will get you every time. It's frequently related to the fact that practices that are common in most other unregulated industries aren't permitted and can get you into a lot of trouble if you're a healthcare provider. Next slide, if you would. This is just a slide that shows you the anti-kickback statute. I'm sure most of you are aware of it. It prohibits solicitation, offering, paying, or receipt of remuneration in exchange for or to induce the referral of beneficiaries of healthcare programs. It's got criminal penalties, including jail time, which you'll see in some of the cases we'll talk to you about, plus fines. There are significant penalties. You can also be excluded, and remuneration is anything of value, obviously very vague. Next slide. The anti-kickback statute has what's called a one-purpose rule, and it's had this since the Alvin Grieber case many, many years ago. Even if there are lots of other valid reasons for remuneration, if even one purpose is to improperly induce referrals, there's a violation. The concept of intent is not the intent to break the law, but rather generally the intent to do the act that is illegal. So ignorance of the law or the fact that the act is illegal generally is not treated as an excuse. There are a number of gray areas, a bunch of safe harbors, and the fact that you don't necessarily, your practice doesn't necessarily meet a safe harbor doesn't necessarily indicate that it will be found in violation or viewed in violation by the Office of Inspector General. And again, I'm sure you've heard this 100 times, or justice, but nevertheless, it also doesn't give you any kind of immunity. So you really need to talk to counsel when you get into these areas to help you analyze it. Next slide. Heidi? Heidi?
Sorry, was having a coughing fit there. Hello, all. Real briefly on the Stark Law, you all know this is the physician self-referral prohibition. And the important thing about Stark is two pieces. One is sort of what is the designated health service. And it has, the second piece is that it involves a physician or immediate family member. And a third component to this, which people don't always think about, is that the physician or the family member has a financial relationship with the entity to which the patient is referred. And this can be an ownership, investment, or compensation relationship. And what we see a lot is that people really don't pay attention to the compensation relationship. They focus a lot on the ownership one. Lots of exceptions similar to safe harbors, although they're not identical. But again, really the Stark Law is what we need to pay a lot of attention to on these things. Next slide. Again, there are designated health services. There are 12 of them. The three that are most particular to hospices and home health agencies are, of course, well, mostly home health agencies, are physical therapy, occupational therapy, and of course the home health services themselves. And these are all by definition in the statute. The thing to remember about the Stark, yeah?
Go ahead, Heidi. Go ahead, Heidi. I'm sorry.
I was going to say the thing to remember about the Stark Law is that unlike the anti-kickback statute, there is no need to prove intent. So if you do not fall into an exception, by definition, the situation is a violation and you are subject to the penalties and disgorgement of all the reimbursements that you had received. Michael?
And just one quick comment for those of you that also may be in the nursing home business. Although you don't have nursing facilities or skilled nursing facilities as a designated health service, as an example, if you're providing physical therapy and occupational therapy in those in that venue, then that part of it becomes a designated health service for analysis.
Right, right. Okay, next slide. There are some other statutes that we need to keep in mind as we look at these in terms of marketing practices. The Civil False Claims Act, that is the whistleblower statute. And again, a lot of times what you have is you have a prosecution starting as or a lawsuit starting as a whistleblower claim, and then the governmental entities join into that. And again, there are whistleblower rewards that come under the Civil False Claims Act. You've also got a Criminal False Claims Act, a False Statements Act, and these basically all essentially prohibit knowing submission of false claims or false statements. So it's not just submitting a claim, but making a false statement in your records. And you've got, again, penalties, treble damages, possible prison, and again, the whistleblower lawsuits. Didn't want to spend a whole lot of time on the law because I presume everybody pretty much knows this, but again, we would be remiss if we didn't at least make a nod to these statutes. Next slide.
Yeah. In the next portion, we're going to talk about the compliance guidance that's been issued by the Office of Inspector General for home health agency and hospices. And we'll be looking at the risk areas that the OIG has actually flagged in those guidances. They're, by the way, mandatory reading for home health and hospice if you're in that business. They're somewhat dated, but they're based on real-life practices, some of which we've seen more recently, and the government and practices that the government has either seen, investigated, or prosecuted. We're also going to discuss several other OIG issuances that are relevant as well. Next slide, yeah. Basically, the OIG program guidance for home health agencies discusses a number of risk areas. We've set them out here that are related to marketing, including improper patient solicitation activities and high-pressure marketing of unnecessary services, free gifts or services to patients, and non-deceptive and clear marketing information. There are some exceptions on this. You are permitted if it's not in cash or cash equivalents. At the federal level, there is a safe harbor of gifts at $15 or less on an individual gift and $75 or less over a year. But again, they can't be cash or cash equivalents. And Heidi will talk to you about some even more restrictive Texas limits on that. You also have the issue of improper influence over referrals by hospitals that own home health agencies. Hospitals are supposed to provide lists, as you all know, but there is also an exception that in certain alternative payment methodologies, such as the Comprehensive Joint Replacement Program, hospitals are allowed to have preferred providers under those circumstances. And then on some of these others, we'll be talking a little bit in more detail about real life examples that some of us have, that I've seen, I'm sure Heidi has seen. But one in this last bullet that we'll be looking at is space rental, and also one of them I was involved in actually in an investigation where an email sent by the compliance officer that was turned over to the government seemed to indicate that there was a problem on the issue. It turns out that the company was doing everything right, but thanks to the compliance officer's email, they had to go through an investigation and a fair amount of expense. By the way, that's also just a lesson on training your employees on the use of email. This is a quote right out of the home health agency guidance regarding offering of free gifts, free services, and you can read that. But one of the things you might want to consider is, especially depending upon your size, having legal counsel review all your contracts. That's actually suggested in the guidance. Obviously, if you're a small agency and you've got a bunch of contracts, you may have to pick and choose, but it's always a good idea to have at least someone take a quick look at them. The compliance officer is obviously tasked with ensuring not just that everyone in your company is aware of the rules, the issues in getting training, but also your contractors and agents who are involved in this as well. And it's especially important with respect to independent contractors who are involved in marketing. It makes, again, the guidance requires you to train and monitor the activities of everyone related to marketing, especially the independent contractors. And we're going to discuss some cases later on where recruiters paid patients and aides, and also discuss some civil contract disputes with recruiters, which used to occur and which was sort of like pouring napalm upon yourself. These are just again some more quotes from the compliance program guidance, talking about training. But again, it emphasizes the importance of training independent contractors responsible for marketing. Also, audits need to be designed to look at marketing, and for example, you may want to monitor whether you see a major uptick in referrals from the same referral source. Can we go to the next one, Selma? The next issue, the next slide talks about a special fraud alert for home health agencies that lists a number of things that OIG had seen. The top one, offering free services to beneficiaries. Again, as we mentioned, if they agree to switch home health agencies, one of the things that I'm sure you're all aware of is that a lot of the complaints to the OIG come from your competitors. So again, it's not just doing the action, but also when you infringe on the business of others, you can expect that they're not going to be sitting back. A second one is providing free services to retirement homes or adult congregate care homes or in return for referrals. I've actually been involved in an acquisition where the acquirer rejected a number of contracts because we saw this type of activity, and in fact, the administrator either was let go or re-educated very harshly on that. Subcontracting with retirement homes or adult congregate care living facilities for the provision of home health services to induce referrals to the agency. All of you folks, many of you folks may be leasing space in home health agencies, and there's nothing wrong with that. It's a common practice. But if you're going to do that, you need to make sure that there's A, no requirement for referrals, and B, that you're paying fair market value for space. I had an instance years ago where I actually talked to an administrator, and he jokingly said, "I guess I have to bargain for less money the next time." To my in this instance, it was a therapist, and I said, "Yep." And again, again in an acquisition, you may find that if you're paying too much, or even the assisted living facility sees in an acquisition that you're paying too much, they may reject you. One way to figure out fair market value that we've used in the past is to find a medical office building in the area and figure out what the square footage of the space would be. The others are obvious, but again, it's worth being aware of them. Next slide, Salma. Now we're going to talk a little bit about the OIG compliance guidance for hospices. again, you've seen, I'm sure you've all seen a number of these issues. One of the big issues, obviously, are, among other things, paying kickbacks to physicians for terminal illness certification or other services to physicians. And again, we're going to talk about nursing home relationships separately because those are a major focus and have been for years. And again, just to remember that these are real life examples that the OIG has seen. On this slide, I think the one thing that we'd want to focus on is, again, this is out of compliance program guidance for hospices, is high pressure marketing. You shouldn't offer free gifts, and again, we've talked about the exceptions. $15 per item, $75 per year. Again, they can't be cash or cash equivalents, and Heidi will talk to you a bit about Texas. And you can read the remainder of those. Again, some more of the risk areas that were pointed out. The improper solicitation activities, such as what they call patient charting, or what we tend to call rifling through mining resident records. You ought not be going into either a hospice, either a nursing home or an assisted living facility, and without request by the patient, actually just going in and reviewing records. That's a big red flag. You also don't want your sales commissions based on length of stay in a hospice. Now, one of the things to be aware of is that there is an exception. It's called the employee exception. It's a safe harbor. But the employees have to be bona fide W-2 employees. They have to be meeting the IRS standards of employee. And Heidi and I will both repeat this again and again. The OIG still is looking and doesn't necessarily buy the employee exception for marketers, especially under certain circumstances. We don't like, we like to see our clients paying all marketers, meeting the personal services safe harbor, which means that you pay at fair market value. You don't take into account the value or volume, even if you're dealing with of sales or revenues, even if you're dealing with employees. So at any rate, we have the same admonition for home health agencies as well. Again, still coming out of the OIG has some separate guidance for a separate fraud alert for relationships with nursing homes. And there's also, as you guys I'm sure are aware, the regulations, the conditions of participation also specifically address these relationships. The four things you should be worried about. First of all, the big issues. If you're dealing with Medicaid patients, the hospice, as you know, gets paid 95% of the Medicaid rate for room and board. You shouldn't be paying the nursing home anything more than the full Medicaid per diem for room and board when you're dealing with Medicaid patients. You need to make sure that the hospice is doing the services, all services, except what you'd expect to be provided by relatives in the home. You can't do nursing home functions for those folks, which are functions related to the room and board. And it's not always that easy to distinguish the functions. For example, you have nurse aides who are used to caring for patients, and it takes training both at the hospice level and the nursing home level. And don't send as we said before, don't send employees to be mining the nursing home records to try and find hospice patients. Again, out of there, these are some real life examples that the OIG found. Two that come to mind and that you'd focus on are the hospice paying amounts to the nursing facilities for additional services that Medicaid considers to be covered under the room and board payment to the hospice. They'd look at that as a kickback, or the hospice paying above fair market value services that Medicaid doesn't consider to be covered in the room and board rate paid to the hospice. You can, again, you guys know this, you can subcontract for non-core services, but you ought not be paying over fair market value. That's a red flag to them as well. And the last slide in this area is hospice providing staff at its expense to the nursing facility patients to the hospice. And what wasn't on here is to perform duties that otherwise would be performed by the nursing home. We've discussed earlier, don't rifle through patient records. We also have an OIG bulletin regarding the offering of gifts and inducements to beneficiaries. If you go to the next slide, Selma. Again, this slide just sets forth the exceptions under the federal rules, but again, under Texas rules, they're more stringent. Next one. The importance of this particular guidance is that it was issued more recently than the others. OIG was seeing these issues in June of 2016. They're obvious real-life examples, and if you don't think that some of these are still going on, Heidi will be talking to you about some cases that jump out at you. Next slide, if you would. Big issue is payments disguised as payments to medical directors. Years ago, I was doing acquisitions for a major entity in the Southeast, and we literally had our consultants who were doing due diligence taking a look very carefully at home health agencies in the state, and they didn't find one in that particular area that wasn't paying various rates. Well, they found one, excuse me, that wasn't paying various rates to different medical directors, presuming that, and would have numerous medical directors that appeared to be based on volume of referrals. It was an issue then. It's a big issue here. We simply walked away from those deals. And obviously, on the last one, homebound is a very big issue, whether it's here or for audits. The next is, again, a more recent one, compensation, an OIG fraud alert on physician compensation arrangements that they found problematic, and they're real life cases. You can read you can certainly read the slide, but just remember the real life cases. Heidi, you're next up.
Yeah. Yep. Thanks, Mike. So a couple of points that I want to make before I jump into the rest of these things. If you have not yet read the compliance guidance, you should. This is your homework for this week. And the point that I want to make about all of these things is not so much the newer fraud alerts, but the compliance guidances have been out for 20 years. 20 years, since 1995 and 1998. And truly, the OIG's expectation is that you will not have read those just once, but multiple times, and that you will take that guidance and have woven that into your compliance program. And, you know, one of the things is if you come under scrutiny and you show little understanding of what is in those compliance guidances, it is going to go worse for you. Because that is definitely their expectation, that this guidance has been out there for 20 years now, and everybody should be aware of it.
And Heidi, that's great. That's great. That's a great tip. The other thing to remember is on your training, because again, if something goes wrong, they'll be looking at what kind of training the compliance officer provided. And again, these risk areas are certainly obvious topics. Although again, Heidi's going to talk about a case where the compliance officer appeared to have given training, and as you read it, you almost think you could almost see it as the news section on Saturday Night Live. It's so blatant. But anyway.
Yeah. So among the other kinds of guidance that are out there are OIG advisory opinions. And essentially, if you have a situation that you think might violate the anti-kickback statute, you can actually request an advisory opinion from the OIG. And so what you do is you submit a packet that describes the arrangement, any contracts or letters or forms and so on. And the OIG will then evaluate it. And if they issue a favorable opinion, what they will say is that they will not prosecute this particular arrangement. Then you've effectively got a get out of jail free card. The flip side is if the OIG issues an opinion that says, no, this is violative of the anti-kickback statute and we would prosecute it, then you are now on notice that your particular arrangement or transaction is a violation of the law. And if you move forward with it, well, you know, the OIG advisory opinion is going to be Exhibit A. So as an example of this, there is Advisory Opinion 15-2, and it specifically looked at a home health agency offering free introductory visits, and that free introductory visit is not a covered or reimbursed service. And the way the agency was chosen was, again, as Michael said, it was a list of HHAs provided by the physician or the hospital, and then the patient was contacted and offered the introductory visit, to discuss care transition, pictures of the care team, and so on. The OIG in this particular circumstance found that the practice did not violate the anti-kickback statute, holding that the visits did not constitute an improper remuneration to beneficiaries. And we put the link here to that advisory opinion so that you all can read this. I'm going to make the note that these OIG advisory opinions only apply to the anti-kickback statute. There is a separate provision for getting a Stark opinion from CMS, but there are really only a handful of Stark opinions out there, none of which deal with home health agencies. So really, you have to remember, again, that you have the anti-kickback statute and the Stark law. And so we really only have a bunch of opinions from the OIG on the anti-kickback side, not on the Stark side. Mike, you had a...
Yeah, I'm sorry. Heidi, do you mind if I just want to make two quick points here. One, you want to you want to use attorneys if you're going to go for an advisory opinion or a really savvy compliance officer. These opinions generally involve also a lot of give and take with the folks over at OIG, and among other things, you may decide at some point as you're talking to them, if you're going to get a negative answer, you may simply want to withdraw it. The other thing that we've seen out there, and in fact, I was almost involved in one. One of my clients saw a competitor doing something that they thought was blatantly illegal, and they didn't want to have to take those kinds of risks to compete. So we were talking about the possibility of even doing a defensive, going for a defensive advisory opinion to get something out there on record saying thou cannot do this in order to put the fear of God into their competitors. So there are two ways you can look at advisory opinions.
Yep. Good points, Michael. Thank you. Next slide, please. This slide basically is just going to mention that, again, as part of all of this, the OIG, again, has active audits and investigations. These are all on their work plan out on the OIG's website. I'm not going to go into a lot of them, But again, you need to recognize that home health agencies are under and hospices are under a variety of kinds of scrutiny and audit. And even though the title of the audit or investigation may not include marketing issues, marketing becomes something that they look at and becomes a topic of concern as they do all of these other audits. Next slide. As Michael said, we also need to worry about Texas state law because, of course, Texas. So there's a couple of statutes here in Texas that we have. We have the Texas Patient Solicitation Act. This is analogous to the federal anti-kickback statute, and it actually permits any arrangement or practice that is permitted by the federal anti-kickback statute. Unlike the federal anti-kickback statute, however, the Texas Patient Solicitation Act applies to any provider and any form of reimbursement or any kind of payer. So in that sense, it is broader than the anti-kickback statute. We also have the Texas Physician Solicitation Prohibition, which is analogous to the Stark Law. We've got the Texas Medicaid Fraud Prevention Act, which is again analogous to the Federal False Claims Act and applies to Medicare claims. We have a new thing here in Texas. I shouldn't say new. We have a statute that we've never really looked at before, and that's the Texas Commercial Bribery Act. There is no federal equivalent. There are no safe harbors under this law. And again, this is a sort of a general business bribery statute. And it basically holds that a fiduciary commits the offense if, without the consent of the beneficiary, the fiduciary solicits, accepts, offers, or confers or agrees to accept or confer a benefit that would influence the conduct of the fiduciary. So you see a little bit of the similar language: solicit, accept, offer, give. Here is the interesting thing here is that a physician is considered a fiduciary under this law, and a violation is a felony. Well, why is this important? Well, because the government has now begun using another federal statute called the Travel Act to bootstrap convictions. And so this is actually what happened in the Forest Park case, which, if you were paying attention to Texas news, wrapped up at the end of March, where the physicians went to trial, and the government actually prosecuted arrangements based on the Texas commercial bribery statute. And if, for those of you who don't remember the Forest Park, basically it was a physician-owned hospital, and they were out of network, and none of the patients allegedly were federal beneficiaries, Medicare, Medicaid, and yet the government still managed to get a conviction, finding the jury found that the physicians violated the Texas commercial bribery statute, and that in and of itself was a violation of the Travel Act. So things to be aware of here in Texas. Next slide.
Yeah, and just one comment, and it's not Texas. Virtually every state has some form of commercial bribery act or in essence private pay anti-kickback act. So when you're getting involved in something, even if you're not treating Medicare or Medicaid or federal patients, you still have to be aware of those statutes. Although generally, for example, in the under the Commercial Bribery Act or under the Travel Act, the government would be looking for pretty egregious conduct. But you want to take a look at the state law, even if it's not Texas, if you're in another state.
Correct. One of the other things that Texas has is guidelines on marketing, and these are for providers that are enrolled in Texas Medicaid and the SCHIP or CHIP programs. A couple of prohibitions here. You cannot do unsolicited personal contacts, such as by telephone or email, so basically no cold calling. You cannot offer inducements or giveaways of more than $10 value, so this is much more limited than the federal level. You cannot offer gifts or inducements designed to influence the providers, the beneficiaries or individuals, patient's choice of a provider. And the reading level on all marketing materials cannot be greater than the 6th grade. So these guidelines actually have checklists. And the nice thing actually about this is if you have marketing materials and you want to see if they're acceptable, you can actually submit them to Health and Human Services for review and approval. And they have a relatively quick turnaround within 30 days. And we put the link here again for the marketing guidelines. So again, this is very specific to Texas Medicaid. If you have Texas Medicaid, you really need to look into this as well. Next slide, please. So to summarize some of the examples of problematic practices, of course, sham directorships. This is a huge and ongoing issue, and you'll see that come up in one of the cases we discussed. Agreements with nursing homes to send patients to a particular hospital. Marketing materials or agreements that fail to discuss a terminal illness, and that's particular to the hospice situation. Free or below market value services provided by the hospice to the nursing home. Referring a home health or hospice patient to a nursing home in exchange for the nursing home referring back hospice patients. Multiple medical directorships with compensation based on number of referrals. Next slide.
Yeah, and that and that one, yeah, I think Heidi, the next one. Oh, I'm sorry. The next, yeah, and that the multiple medical directors, as I mentioned, we've seen that, and that's going to get, even if you ever want to sell your agency and you have a savvy purchaser, even if it's not picked up by the government, you're going to find that in a difficulty. The next slide, obviously, again, we've gone over this. You don't want to be paying patient recruiters or marketers based on volume or value of referrals. You've got the employee exception. But again, you want to be careful about that because that applies, in essence, to services, and the government doesn't necessarily view, OIG does not necessarily view marketing as a service. The excessive payment for space rentals to the ALF, we've discussed real life examples of that. Payment by staff of a home health agency or home care agency to patients or sham patients to bill for services never rendered, or for patients/clients who would not be eligible for services based on condition. That's a real life example. That about 3 or 4 years ago, I was awakened by a client when I was out in Las Vegas. 25 FBI agents were in there walking out with all of their files because they and about 70% of the DC home care providers were allegedly had issues of, among other things, AIDS. AIDS basically splitting the payment with patient Medicaid payments with patients or people who shouldn't have been patients. There was even in one of the indictments, there was a guy literally flown back from another state to be in his home because they had gotten word that as you know, many home care agencies have people going behind and making unannounced visits. Well, internally, they knew the visit was going to occur. So they literally flew the patient in from out of state, who was out of state. And as I say, that was 70% on one afternoon. If you talk to certain people in DC government, they'll tell you 70% of the agencies were lost in that short period. And then we've listed a couple of others, payments to patients who aren't homebound to use a Medicare number to bill for services never rendered or covered. Frankly, homebound is a huge issue in non-fraud areas, let alone fraud. And home health agencies going through the medical records of skilled nursing facilities or assisted living facilities. Next, Heidi.
Yeah, so now we're going to get into discussion of some of the cases. The first one is U.S. versus VITAS Hospice Services. This is from Missouri, 2017. The allegations here were that VITAS engaged in marketing campaigns that misrepresented the purpose of hospice. So they didn't really focus on the terminal illness and instead promoted quote unquote intensive comfort care. VITAS trained its marketers and paid employees bonuses based on the number of patients enrolled. So again, productivity, and also paid bonuses based on patients who had longer stay and need for continuous home health services. So the evidence came out that they had set goals for the numbers of crisis care days to be billed. That's obviously problematic there. And again, the evidence showed that marketers who did not meet monthly admission goals were terminated or disciplined. VITAS failed to train its medical directors on hospice eligibility criteria. One physician admitted that VITAS did expect him to certify the patients without actually making a determination that the patient had 6 months to live as required. Another interesting thing here is one physician actually refused to certify certain patients, but then was overruled by the medical director. Another physician was also overruled by the medical director when he attempted to discharge patients that he thought no longer qualified. Part of the problem here is that several of the VITAS medical directors actually conducted their own internal review of the San Antonio location, and they discharged 75 to 80 patients for failure to meet eligibility criteria. So this was kind of a blinking neon sign about issues with patients meeting eligibility criteria, but they never took any further steps and, expanded that to other locations. They never did anything more with those patients. They never looked at the billing and so on. Next slide. As part of this review, one of the physicians informed the VP of operations that the medical director for San Antonio had knowingly admitted and certified ineligible patients. And again, nothing further was done about that medical director or about those patients. Again, all of this sort of comes to summarize that the patients didn't meet criteria for a variety of things, for eligibility, for crisis care. They were perhaps home health patients, probably didn't really need hospice care. And as a result of this, VITAS repaid $75 million to the government, plus the relators' fees and attorneys' expenses. So that was another $10 million. And they signed a 5-year corporate integrity agreement. Next slide. Another case that is on the radar screen is the Jacques Roy situation up here in the Dallas area. Again, if you were paying any attention, this was a pretty egregious case. Dr. Roy had 11,000 plus patients. He was a family practice / general practitioner. And he was affiliated with 500 plus home health agencies. And the way this works is the home health agencies would identify patients. They would refer them to Roy. Roy would then, quote unquote, refer them back to the home health agencies. And again, he had these agreements with multiple home health agencies. Some home health agencies had approximately 80% of their patients so-called referred by Roy. The evidence that came out is that his office handled more alleged home health visits than any other physician office in the country. And again, as you can imagine, with this kind of volume of plans of care and research and so on, there was just no way that he could be doing all of that. So he actually had his employees help him out by signing his name to the POCs and the certification. This situation was compounded by the fact that when Dr. Roy's first practice was suspended, he created a second practice which paid management fees to the first practice, and this was done in order to keep all of the home health agency scheme running. Dr. Roy was sentenced to 35 years about a year ago, so he will spend the rest of his life in prison. Some of the home health agency owners have been sentenced from 3 years to 17.5 years, and we are still seeing up here in Dallas the fallout from the Roy Jacques situation. And we've also seen that nationally. I mean, this was part of the reason why we had the moratorium on new home health agencies, because Roy Jacques and all the fraud down in Houston. Next slide. Another case is a whistleblower case. The XREL tells you that there was a whistleblower, a young woman named Cordingly, versus Good Shepherd Hospice. This was out of Missouri. And Good Shepherd was based in Oklahoma City, but provided services in Oklahoma, Texas, Missouri, and Kansas. And the whistleblower was actually the executive director of one of the Missouri offices for about 6 months. And the evidence here was that the hospice hired medical directors solely on the basis of their ability to refer patients, and they focused on medical directors with ties to nursing homes. So the medical directors each worked about 2 hours per month and received approximately $3,000 salary monthly. Man, I would love that kind of salary, $1,500 an hour. That would be awesome. The hospice also required medical directors to refer at least one patient per month. One medical director was terminated. His contract was terminated for failure to bring in enough referrals. And he actually sent emails saying that he was concerned about the quality of care provided by Good Shepherd Hospice as his reason for not referring patients. The hospice would also keep at least one patient in a nursing home as a hospice patient, and this was so that they would have continued access to the nursing home to be able to market hospice services to nursing home patients, nursing home patient family members, and the staff. Next slide. One of the things that came out was actually they had an email or a wiretap, I don't recall which, but basically if you give me 5 patients, I'll put a nurse's aide in your building all day long. So again, providing staff to do services for the nursing home that the nursing home didn't have to pay for. We also had the common thing of gift baskets and free lunches. Again, in order to achieve a quota, the marketers had to achieve 5 admissions per month. So Good Shepherd settled for $4 million and a corporate integrity agreement. Next slide. This is a newer case, Serenity Marketing. So we had an individual named Sunday Williams. She owned a telemarketing company, and what she did was make cold calls, phone calls to recruit patients for home health services. And then these patients were then referred to a number of Chicago area home health agencies. The home health owners and agencies paid her for quote unquote marketing services. And they actually entered into contracts that said these services were paid for at an hourly rate. But the problem is that Serenity Marketing and Ms. Williams never actually tracked the hours that they worked. And they billed the home health agencies by converting each patient referral into a made-up number of 10 hours worked. So if she referred 3 patients, then she had 30 hours worked. And what she usually got was $60 per patient. She decided to go to trial on this and was
600.
600, yes, my apologies. Yes, 600. She was convicted at trial and sentenced to a year in federal prison and has forfeiture ordered of just shy of $600,000, which was the revenue that she got from this scheme. In addition, we have also a physician who signed the referrals, another physician who was outside and working with the home health agency. He was doing home visits. And a nurse, Ms. Gumilla, who was working with Dr. Newman, they were also all sentenced and have all received prison terms. And as you can see, some pretty significant restitution ordered for these individuals as well. Next slide. Here's a new case, relatively new case from Texas. Ms. Ainabi, I think is how you pronounce it, was a patient recruiter for Texas Tender Care, which she owned. But what she tried to do was she tried to make it look like she was also an employee for other home health agencies, being paid a legitimate hourly wage to work as a marketing representative. But again, in fact, she was being paid strictly on the basis of patient referrals. Here, going back to the comments that I had made earlier about the anti-kickback and the Stark Law, she was also a shadow owner, meaning she received a portion of the Medicare payments after the other individuals paid for their roles. But the problem was she wasn't listed as an owner of the company in any state corporate filings or on any other document. So hearkening back to my comments about making false statements in federal and governmental records, here's an example of that. When Ms. Ainabi had patients, she then turned and paid doctors kickbacks to authorize the home health services. She also paid physical therapists and others to complete paperwork, the certifications and the visit logs and so on. And after a jury trial, she was sentenced to 9 years in prison. Next slide. Here's the case that I really wanted to talk about the most. This is another whistleblower case. It was just unsealed May 24th in Florida, which is why we have the 2019 date. But it was actually originally filed in 2015. So basically, a whistleblower case is filed under seal, and then the government has the opportunity to investigate. So this case was under investigation for 4 years, and oh boy, did they come up with a cornucopia of bad evidence for these folks. So again, what they did here was they paid 3 referring physicians to refer patients, and they did it in the form of sham directorships. And again, if they did not make sufficient referrals, the directorships were terminated. Doctor's Choice Home Care very closely tracked the payments and to physicians and compared them to referrals. They also hired the spouses of the physicians as employees, and they paid these spouses in a manner that accounted for the volume of referral, again, looking back at the tracking of the referrals. This case is particularly bad because the evidence shows that the employees were actually given compliance training, and there was actually a 2004 presentation that explicitly discussed issues with compliance issues with medical directors. Unfortunately, that was counteracted by all these emails that the owner sent to the account executives being the marketing personnel. So you had emails saying things like, when I see dinners, I expect some business, or Dr. G is not working out as a med director. He has only given us 17 referrals in 6 months. I think we could find someone more productive with his spot. We've paid him $6,000 so far. Another email was, Dr. G gets an F this month. And then a fourth email, these are only the selections that I made. Trust me, there are multiple emails in the documentation. Medical directors are not doing good. My suggestion is to have a talk with them and let them know what the expectations are. Next slide. So with this kind of information, you can well imagine that the relator was an account executive, a marketing rep, and she actually had explicitly related concerns that one of the physicians, Dr. S, was not performing the services identified on his invoices. She became so unhappy that she actually left to go to a competitor, at which point Doctor's Choice emailed Dr. S to prevent him from following her to a competitor. And the email said, if you're not going to give us 50% of the business, we'll be forced to do the following. Personally meet with each and every family, general, or internal medicine physician to explain your financial relationship with the physician, and notify all state and federal agencies of the marketing exec's illegal activities, and let me know your intentions, or we will assume you are going to be giving the competitor 100% of your business. Really bad documentation.
Yeah, and just to, Heidi, just to break in here for 1 second, you will see, especially in earlier years, where after going through an arrangement where a home health agency or a provider would pay a recruiter for per patient referrals, all of a sudden the provider would decide not to pay the recruiter, and you'd see lawsuits going back and forth claiming that the contract was an illegal one after they'd participated in it. Not a wise idea. If you're having a contract, first of all, don't get into those contracts, and if you're having a contractual issue, make sure you get a healthcare lawyer to talk to you before you file a lawsuit that says says we're both breaking the law, therefore vitiate the contract.
Right. Good point. Next slide, please. So again, just looking at Dr. S. So Dr. S gave lectures to the public to market himself or his practice. Doctor's Choice arranged for and paid the costs of this. And then, of course, Dr. S went ahead and invoiced a sister entity for the time he spent giving those lectures marketing his own practice. He performed chart reviews, but the chart review forms reflected no meaningful work, and most were signed without comment. He submitted an invoice for 7 hours to learn their online portal for patients and 8 hours on a handbook that was to be distributed to his own patients about his practice. So again, the compliance officer raised concerns about the lack of documentation, said she didn't remember a 3-hour in-service that Dr. S had submitted an invoice. Next slide. Two of the other physicians, Dr. J, signed a medical directorship agreement and got his first $4,000 payment before doing any work, and that check was accompanied with a stack of patient charts to review. Within an hour, he returned the signed charts to the account exec along with an invoice for 9 hours of work. And when the account exec challenged him on that, saying, I'm not sure why you're billing 9 hours in the space of an hour, he insisted he had done the work. The marketing rep went to the CEO, who told her to leave things alone and just keep on getting referrals. Dr. F was an interventional pain physician, and he was also contracted excuse me, to perform in-service training. Those in-service trainings consisted of Doctor's Choice staff being sent to his office to watch him perform routine procedures. He also then became a medical director, signed invoices that charged an hour time for each chart reviewed. And often what would happen is the account execs would drop off the charts and wait while Dr. F, quote unquote, reviewed the charts and signed the forms. And he was actually told by other personnel at Doctor's Choice that it didn't matter how much time he actually spent on chart reviews. So you can see this is a pretty bad circumstance. As I said, this was just unsealed, this case, so they haven't gotten very far. If they go to trial, based on this documentation, I think a conviction is going to be a slam dunk. My guess is that the folks at Doctor's Choice would be wise to just agree to plead guilty on this and hopefully avoid really extensive prison times, but we shall see. There's one more case here.
And just one comment. These are still allegations. We're assuming that there's some truth to them. But it is just a complaint, it's just allegations. We're running a little over, but we will be quick. And there's one section after the next case that we think is valuable to everyone on tips.
Yeah, and I'm just actually not even going to cover the next case, so we can go right to the tips. So if you want to move ahead, again, you can read this at your own leisure. Okay, so based on all of this, we've got some tips and best practices. The first, of course, is to understand thoroughly the anti-kickback statute and Stark law. Again, these have been around for a very long time. There's not an excuse to not understand these. Ensure that every relationship with a physician is documented. You want to make sure that every contract and arrangement with the physician is reviewed by a healthcare attorney. There are way too many pitfalls here, and with all due respect to other attorneys and general attorneys, it is my experience that they are not aware of all the hidden pitfalls and traps in healthcare. So don't rely on your real estate attorney. Don't rely on the person who handles your traffic tickets. Don't rely on the attorney who has done your sister's brother-in-law's cousin's traffic ticket. You need to document valid business rationales for any agreements and fair market value of services and items. And you want to ensure that your employees are true employees and not just, quote unquote employees being paid like employees. You really want to make sure about that. Next slide.
And on the next slide, we've talked a lot about this, but make sure your medical directors should be compensated solely based on clinical and there should be an administrative services in there. There can't be any link to referrals or admissions. That's an obvious one. You want to document the time and effort to support the medical director's services. So you don't want to see a medical director, again, who you're paying a fairly substantial salary, or I should say amount to, and they're not doing any work. And of course, then they're referring. Train your medical directors on eligibility criteria, Medicare care definitions, and compliance with the law. Compliance training needs to be given to the docs. It needs to be given to all your contractors, especially anybody who would be a referrer or marketer. And monitor relationships with your outside referring physicians, their offices, and marketers as part of your compliance program. You might even want to take a look at spikes in referrals, stuff that looks out of the ordinary in your audits. Next slide, please. Okay. Just again, an obvious one: carefully evaluate compensation plans for employees. I can tell you that incentive payment, and it shouldn't be based on the number of admissions or lengths of stay. Again, we talk about the bona fide employment safe harbor exception, but the OIG still, and with respect to marketers, will look askance to some degree at this. So you have to be careful. And I think the big issue here is if there's something else going wrong, then this will get dragged into it. Incentive payments shouldn't be based on individual economic production. Certainly not for your marketers, but I'll tell you, I think Heidi and I both agree on this one issue. I don't even like bonuses based on even individual or even location production. And the reason for this is not that there's anything necessarily wrong there. I say necessarily wrong. The problem is that if something goes wrong, then the OIG or the Department of Justice will sit back and will come in and say, yeah, but you guys incentivized this by the way you paid your employees. A better way, if you're a larger company, might be to incentivize employees based on the profitability of the company overall, under quality, a whole different bunch of ways. But again, you'll talk to your counsel about that. Compensation for marketing by independent contractors should meet the personal services safe harbor. We've talked about that. and you've got to make it at fair market value and not based on value or volume of referrals. Heidi?
Yes, next slide. Oh, we are here. Okay. Again, you need to separate your marketing function from your intake and admissions functions. They should be different individuals. And your intake and admissions personnel also should not receive bonuses based on the number of new patients admitted. You really want to stay away from quotas for admissions and not fire people for failure to meet specific numerical quotas or goals. And this is just part of parcel. I mean, while you are running a business, we understand that, but as part of the marketing and admissions function, you really don't want to have a lot of focus on numbers and revenue. You should routinely check your referral patterns. Unless you're in a rural or underserved area, you should not have more than approximately 20% of your referrals coming from any one physician. And actually, this came from one of the prosecutors in the Jacques Roy case. When I was talking with him, he said this is sort of the internal standard, unofficial standard that the OIG uses, no more than 20% of referrals from any one physician. You want to train your marketers and admissions or research personnel on eligibility criteria, what the definitions are in Medicare, and how to comply with the law. And unlike in the doctor's choice case, if you do those training sessions, then you need to adhere and abide by what is in your training sessions on compliance with the law. You want to be monitoring the marketing practices of your independent contractors as well as your employees and what their relationships are with referral sources. Because again, they are acting as your agents out there. So if they're doing something wrong, the belief is going to be that they are doing so at your direction. Next slide, please. Again, based on the Texas law and some of the other things that we saw with the hospices, you want to evaluate your marketing materials and your approach to patients. You want to ensure that patients and family members understand the purpose of both home health and hospice services. You want to avoid giving gifts or freebies to patients or family members. If you do have gifts that you want to give, remember to stay under the value of $10 per gift and $50 total per patient. If we have somebody who is outside of Texas, remember that federal policy allows a little bit more, but in Texas it's $10 per gift and $50 per patient. I would advise using the checklist.
And Heidi, one more point, and it's one you always make as well, which is, and those gifts ought not be cash or cash equivalents.
Correct. Right. So, you know, a pen, a notepad, you know, a listing of emergency numbers to call locally, that's fine, but nothing that is a gift card or anything like that. Use the checklist in the Texas Provider Marketing Guidelines. They are very good. And avoid offering free or discounted services to other healthcare providers or facilities in connection with home health patients or hospice patients. And again, this is especially important in hospice relationships with nursing facilities, as you saw by that one case. Next slide. So our final tip on this is, if you have any doubt about your marketing practices, ask. This is not a situation where the adage, it is better to ask forgiveness than permission applies. If you have to ask forgiveness, you are in trouble, definitely in a lot of trouble. So make sure if you have any kinds of questions, you ask somebody who is aware of all of these limitations and laws and so on. I can stick around for a moment or two for questions if there are any out there. Michael, I don't know about you.
Yeah, I can as well. Selma, do we have any questions?
Actually, it seems that we don't have any questions. The only questions are about the slides, which will be sent in 24 hours. But other than that, we have no questions.
Well, thank you very much for your attendance. We're always happy to discuss these issues with you if you've got questions at a later date. And again, thank you thank you for your attending this. And as Heidi said, just be careful in this. Make sure you use your common sense and judgment when you're dealing with marketing.
Yeah, to quote the captain from Hill Street Blues, be careful out there.
Okay, thank you, Michael. Thank you, Heidi. The slides will be sent within 24 hours, and if you have any questions, you can contact Michael and Heidi through their email or phone number. Thank you, and see you next month.
Bye-bye, all.